Welcome to another edition of the Litigation Psychology Podcast, brought to you by Courtroom Sciences. I am Dr. Bill Kanasky, coming at you from the Dallas office today, Dallas, Texas. And I am very excited about my guest, who I think is fantastic, and I think may even be a little bit of a unicorn in the legal industry, and we'll see why in a second. Mr. Kent Dahl from KND Law out in Spokane Valley, Washington. Kent, how are you today?
I'm great. It's a pleasure to be here.
Kent, I've never been to Spokane. I've never been. I mean, I've been to Seattle like everybody else. Tell me about the area, because it's got to be probably breathtakingly beautiful, right? Is that pretty much what it is? It's like
It,
disgustingly beautiful.
yeah, very beautiful. It's the biggest metropolitan area between Seattle and Minneapolis on I-90. We're right on the border of Idaho. Beautiful scenery. We got a good mix of both rural and sort of metropolitan, because all of
Yeah.
Eastern Washington is primarily a rural area.
That's amazing. Me in Florida, I'm more of a beach guy, but you know what? I get to travel on this job, and
Yeah.
so I hope to get out there. It's like with this job in 21 years, I keep saying like I've traveled everywhere, and then you start to figure out, well, wait a second, I haven't been there before.
Well, if you come
Uh,
out here, you got to go to Coeur d'Alene Lake. Beautiful big lake. Just a wonderful place to spend a week.
Well, if I come out there for work, it'd be one of those like your client may be like, "Let's do this by Zoom." I'll be like, "Oh no, no, I've got to be there. Kent really needs me
Yeah,
there. This is
I
an
need you there in
in-person,
person, man.
yeah, this is an in-person project, and I may need to stay 2 extra days because it's such an important case." So, well, great. Well, Kent, let's start here. You're a graduate of Washington State University.
Yes, I'm a cougar for my undergrad in psychology, actually.
Really?
Yeah, I
I,
got a Bachelor of Science in psychology, got the math side of things, the statistics.
I think that's fantastic, and I wanted to point out because I did my research before this podcast. Um, the Cougars are very quietly creeping up there in the top 25 in NCAA basketball, and do they have a run in them in March? And by the time this posts, a lot's going to happen. But do your prediction now. Where are they getting Sweet 16? What do you got?
They've disappointed me for 20 years.
So you're being
I
honest
don't
with
want to be
me.
the guy to say, yeah, this is a chance, and then a big old goose egg. So and out here in Spokane, we're all Zag fans anyway.
Well, that's
Uh,
true.
yeah, so we're kind of used to the Gonzaga winning a lot, or at least getting pretty far, but then sort of causing us some heartbreak at the end.
Well, speaking of heartbreak, would be the 2017 national championship game where my beloved Tar Heels took down the Zags there in Phoenix, Arizona. So I had to
Broke my heart.
I had to go there. But let's get to real business. I tell you, t tell us about your firm and the types of cases that you work on, and kind of and we'll get into the weeds here,
Right.
but kind of the overall firm philosophy, because by knowing you, and particularly the message on your website, when I was reading it, I do my background before every guest, and I'm like, this guy's a unicorn. This guy's very unique in his approach. So tell us about the firm.
Well, so KND Law it's a smaller firm. If you're into liquor or whiskey, we're small batch, and that's intentional. We don't want to be the big national firm going after the big national clients. We want to have a very client centric firm, and we'll do work all the way from fatalities down to some less valuable car crash type cases. We got a couple fatalities now where the service we sell or talk about with our carriers or with the clients is, if there's an accident involving fatality, we're out there within 24 or 48 hours
Right.
talking to witnesses, talking to the client, understanding what happened, and start sort of developing strategies and helping the client make sure they're not stepping in anything that could bite them down the road. And so that's what we focus on. We also focus on the idea being we're a trial firm or trial centric firm. We don't take every case to trial, and I think there's no way to do that.
Yeah.
But our whole motive or motives of operation here is we want to look at every case as if it is going to trial. So everything we do, we want to make sure that if we're doing it, and we want to be proud of it. So if it gets presented to a jury, like take, for example, interrogatory answers, something very simple. But if you're making objections that you're going to be ashamed of down the road,
Yeah.
probably not a good thing to do. So what we always like to do is do one last look at stuff and go, okay, if this turns out to be an exhibit one, are we going to be proud of it? Are we going to be happy with it? Are we going to be ashamed? And so we always develop our cases with an eye toward trial, and that helps us then to find our ability to settle cases at a reasonable amount. So that's really our sort of operation. And then part of that, of course, is you got to do the CLEs, you got to listen to the podcasts, you got to pick up the literature and read the literature, not only even on the defense side, but you got to read what's going out there with the plaintiff stuff. There's a whole bunch of whole
I'll
bunch of literature out there for plaintiffs, and you're doing
Yeah.
yourself a disservice if you're not reading it and understanding it.
Well, what I've tried to do is do all that work for everybody and then present it on the podcast and in papers. There's a lot out there, and again,
Mhm,
and hats off to the plaintiffs bar because, quite frankly, what I've seen and what I've read, they do a good job on their stuff, and it's out there in the open.
mhm,
And for attorneys to go listen to it or read it, it's right there. I just think, you know, we're in an industry where, the billable hour and there's not a lot of spare time, but I find that, whether it be in hotel rooms or airplanes, or early in the morning if I wake up, I try to squeeze in some time because I think there's a lot of information out there. And if you don't read it and keep up to speed, everything's changing so fast. So I certainly appreciate that. Something on your website, which this is something that this kind of there's this theme here on your website, which I totally agree with. Unfortunately, this does rub some people the wrong way. I am known for rubbing some people the wrong
yeah,
way because I call it like I see it and
right,
I don't care. Because I think one of the main problems is that if you don't identify issues, they just kind of stay there, right?
right,
So tell me about the difference between a trial attorney and a litigator, because this has been something that, like, no one talks about this stuff,
right.
but everybody kind of knows it. And I think that clients, a lot of the corporate clients I work with, they want trial attorneys.
Yes,
And I think one of the problems is, and again, this is where I'm gonna get in trouble, and someone's gonna email me a nasty email.
right,
Go ahead, send them away. I think a lot of people call themselves trial attorneys,
right.
Ken. I think a lot of people call themselves trial attorneys, and they're actually litigators. Talk to me about that.
Well, I think it starts at attitude first. If you want to be a trial lawyer, you got to have an attitude about, I want to present cases. I want to persuade a group of 12 people that I'm right and my opponent is wrong. And you touched a little bit about the billable hour. That in some firms, that's horrendous. That's 2,000 billable hours a year. You don't got a lot of time to do sort of this research and to prep yourself for a trial and read all this material that's out there. But if you want to be a trial lawyer, you got to do that. And I think with litigators, they get stuck focused on the tree as opposed to the forest. So they're really good at, okay, I'm in my discovery phase. I'm going to write 100 interrogatory questions. They're going to be best darn interrogatory questions ever written on the planet. That's great. But is that going to get you anywhere? Is that going to get you the evidence you're going to need to persuade a jury of 12? And so keeping your sort of focus on that end game is how I would define a trial lawyer from a litigator. A litigator, too, doesn't do that extracurricular stuff. And I understand right now it's hard to get a civil case out. I think Spokane,
Yeah.
in particular, didn't have any civil trials in the month of January.
Wow.
And so if you're faced with that kind of venue, um, and if you want to be a trial lawyer, go down and watch trials that are going being presented. Talk to people who have gone through trial. Find the time to make yourself available because there's a lot of stuff that when you get into a trial, you don't know about until you're
Yeah.
there. and it's hard to get that experience. I think mock trials are, talking to juries
Yeah.
through or potential people through focus groups, anything to help you get better at persuasion is going to define you more as a trial lawyer, as a litigator. I think litigators, like I said, just get stuck looking at a tree and miss the forest. And that tree could be a piece of evidence. It could be that they over rely on motions in limine. They
Mhm.
over rely on a summary judgment motion. I've had a few attorneys that will probably spend hours drafting a motion in limine, or I'm sorry, summary judgment. But when that summary judgment fails, they have nothing.
Now what?
They're done, right? There's nothing further they think they can do. And so they're going to go to the carrier or go to the client and say, settle now. And one of the things that I do get a lot of feedback from clients I work with is one of the pet peeves they have is, and this is, I think, the issue with a litigator is they'll have someone say, this, we're going to win, we're going to win, we're going to win, we're going to win. And then, 60 days before trial, on second thought, I need a little more money and or maybe I need a lot more money to get this settled when there's been no change in facts.
I can't
Um,
believe you went there. See, I've gone here, but you went there. You're getting the shit on this. So if anybody sends me a nasty
yeah,
email, I'm
it's
forwarding
me.
it right to you. And by the
I
way,
get it.
everybody's again, this is something nobody talks about. Well, clients talk about it, insurance companies talk
Right.
about it, corporate clients talk about it, and quite frankly, they get really upset, and many
Mhm.
of them have called me complaining with the bill, 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 bill for 4 years, and then all of a sudden, "You know what? And then the client's like, "Well, you've been telling me this is a winner for 4 years. You've billed me hundreds of thousands of dollars, but now it's not a winner. Like, what's going on?" Yeah, I could see how that could create some tension in the attorney-client relationship, right?
Well, an attorney, yes, and attorneys, especially trial lawyers, you got to grapple with your own fear.
Yeah,
You got to understand. Look, trial's scary, and I will not lie. Every time I have gone into voir dire or prepared for my opening statement, I have butterflies in my stomach. But
yeah,
you got to grapple with your own fear, and if you're evaluating a case partially based on your fear of trial, you're not doing a service to your client. And I really think sometimes the defense or any kind of counsel needs to look inward and go, okay, what is my actual value of this case? And I got to put aside my fear. I got to put aside, trial's hard. It could
yeah,
be, 3, 4 week process.
brutal.
And and you got to talk to your family and say, look, I'm gonna be gone for 4 weeks. I'm sorry. But you have to have those conversations. Otherwise, like I said, if you're putting value on cases other than what the actual worth is, you're doing your client a disservice. And I have no problem saying that.
Yeah, and I tell you what, in our industry, what we've been pitching to clients for a long time here, and now it's finally happening, finally, is we've been telling our clients is, let's do some research early in this case. Let's not wait till 60 days before trial, and while discovery is still going on, we can do a focus group. There's plenty to test. We can get a sense of what this case is worth, get some actual answers early in this case versus why wait till the middle of the fourth quarter to start start
Right.
making decisions when we could do this in the first quarter and maybe not fall behind. And I think the plaintiffs bar's done a fantastic job with that. They've been out ahead of the game doing research early. I think the defense bar uh, can do the same thing. Talk to me, and I want to go through each of the phases of the trial and really get your
Yeah.
philosophy and kind of where you've been successful, where you see some of the landmines, and how you try to avoid them. But before we do that, um, talk to me about because there's been a lot of change here in particularly the last decade. Technology, the use of technology at trial. Um, Things have changed so fast, and they
Right.
continue to change. Tell me about your approach and philosophy to trial technology, because this is not going away anytime soon.
No.
It's only going to get more advanced. And I think if you fall behind here, I think that your adversary could maybe outperform you in technology in the courtroom, and I don't think that's a very good thing.
Right. So here recently, we have one program that we have incorporated into our business is TrialPad. And it's a nice way to project and to manipulate exhibits on the screen in front of the jury. You can highlight, you can sort of enlarge the words in the contract. And I think attorneys, again, do themselves a disservice by not trying to keep up on technology. And I know for example, the Washington Bar is contemplating bar question now that are supposed to address or target a potential attorney's proficiency in technology. So this isn't going away. And the one nice thing about COVID, there's not a lot of nice things about COVID, but one of the nice things about it was the legal community had to grapple and accept and adapt to technology.
Yeah.
It used to be when I first started practicing, I had this projector that sounded like a lawnmower. And you take it to this rural county, you fire it up, and you project an exhibit on the wall. Now, most law or courtrooms have computer screens, they have TV screens the jury can see. And federal court, of course, is just way beyond anything state court
Yeah.
even has. But I think one of the things you do as a lawyer is anytime you're looking to present a case, you call the court, say, hey, what kind of technology do you have available? Can I come down there and do a test run beforehand and make sure my material lines up with what they have available so that it's a streamless presentation to the jury? Otherwise, I mean, at this point, if you're not putting PDFs on the screen for your client, for a jury to look at, and you're just reading stuff to them, I think there you got a problem.
I think you have a huge problem. Now that being said, again, this is this is an area that I've researched for many years. What I found to be the most effective is to have a combination of things. While you should and can be using technology, which I think is highly effective, there may be some things you want in the old school,
Right,
3x4, 4x5 board,
right,
a timeline, for example, to keep it up there for an extended period of time. Because the one bad thing about technology is when you hit the next button, right? You hit that next button, that document's gone or that
right.
timeline's gone.
Well,
And you're moving on, which is nice. It's efficient, but you may want that photograph or something to really, be physically right in front of that jury, because you want it to, you want them to absorb that information. You want to use it for more of an extended period of time, and you can certainly use a combination of both. And I find that to be very effective. So yeah, I think trial tech, you need to have somebody at your firm that knows what they're doing,
yeah,
because I think the advances, and now with AI, who knows where this is going, but we know it's not going backwards. And we know that you know, my father's 74 years old, and he's kicking like he's 35, and he's 74. And technology to a 74-year-old right now is commonplace. Like, I'm not going to
yeah,
lose him on technology, right? So even your older folks now, like back in, maybe 15 years ago, right? The older generation, sometimes they'd be a little overwhelmed or confused by technology. Well, now today, I really don't care how old your jury is. They're all on, X or Facebook or
right.
Instagram, and they've got laptops, and they're so accustomed to it that I think it's something that's it's a good thing for them. So let's go through the phases of the trial. Um, and the reason why I think this is important, and why I've done this with multiple guests who have been trial attorneys, is we have a lot of younger and, or say, middle-aged attorneys that listen or watch this podcast. They like to hear from trial attorneys that have experience in the courtroom. As you mentioned earlier, because, well, there's many factors, but um, there's not a lot of trials now like there
Right,
was maybe in the past. So any information I think is useful for all the attorneys, even the veteran attorneys, right? You get veteran
right,
attorneys. I know 30-year veteran attorneys that tell me, hey, I listen to your podcast because if somebody else has a good idea, I want to learn from it, right?
right.
So let's start with jury selection, and we'll assume, let's assume state court, right? We
Okay.
all know what federal court jury selection is like. It's over in about 45 minutes.
40 minutes. The judge may let you talk. We don't know.
Maybe, right? But let's talk about state court. What is your style? What is your perspective in 2024? And what is your objective going into voir dire and jury selection, because I think this is an area I've been told over the years. Most attorneys tell me it's the most uncomfortable experience of the trial.
Right, right.
Like, it's, they love the opening, they love the cross exam, but the jury selection part, they find quite uncomfortable. What's your philosophy?
Well, my first, just keep in mind that some of those jurors are just as scared, if not more scared than you
Yeah,
are. They've never been there in the court, and some of them may never been in the courthouse before.
yeah,
So my philosophy is, look, you got a limited amount of time to identify jurors that, for one, may be highly prejudicial against your client,
yep.
or identify jurors that may be very sympathetic to your client. And you don't got a lot of time to do that, especially in our system here in Washington. It is, here's a list an hour before we start voir dire.
That's so
Go through it.
hard.
It's very
It's so
difficult.
hard.
And you can, some people create a lot of graphs. Um, my whole philosophy has always been, look, I'm just going to be myself. I'm going to be myself in front of this jury. I'm not going to try to be somebody I'm not. I'm going to try to maybe make a few of them laugh, because when I do that, it makes me comfortable, and then I can become more authentic to them. And the idea is to get them comfortable enough so that they can talk to you about their various prejudices, about things that they may have that they're not willing to really share with a stranger. But once you get them talking, you learn, okay, this individual's being upfront with me. And if you get an individual who's upfront with you that for whatever reason will flat out say, yeah, I'm a racist, right? Let's just hypothetically, someone
Yeah,
just shouts that out.
I've
Thank
seen
you
it.
for
Yeah,
saying that. Thank you. So, and ladies and gentlemen, this was a very brave thing to say, because now
yeah,
we know. And that's the
yeah,
process I go through. Now, I've used consultants in the past, especially in big fatality cases, but sometimes you don't have, you're a very simple case, and you don't have necessarily, the client doesn't have the resources to do all that. So really the key to it for me has always been establish a room of being comfortable with people.
because
And
people open up. People
people
open up.
open up. And if they feel like you're just there, to help them and help the process, they'll open up. And I've seen a couple, particularly plaintiffs' attorneys back, 5 or 6 years ago, or even 10 years ago, they get real aggressive a bit with the valuation issue. Would you be
Yeah,
willing to award money? I never thought that was beneficial to them, because people tend to clam up. They tend to say, to stick to their guns. Um, and then the courts won't actually boot them for cause anyway. So it's
yeah,
kind of a wasted process. But that's always been something I tell people is, try to have a free flowing conversation with folks. Be honest with them. Don't be afraid to say something goofy. Like, I have a beard. I have no problem saying, look, I have a beard. Is that going to bother anyone here? I wear leather bracelets. Hey, I have a leather bracelet. Is that going to bother anybody? I mean, you kind of talk to them about your own insecurities a bit, and they'll open up to you.
yeah. Now, how do you handle? Because again, there's this discomfort with many attorneys, defense attorneys, in voir dire, and there's a lot of kind of like your brain plays tricks on you at many phases of the trial, which I'll continue to talk about. But I think, in jury selection, I think this is the time to talk about uncomfortable things, right?
Absolutely.
And so many defense attorneys have told me, like, you're crazy. I don't want to poison the jury. I'm like, hey, that's a myth. You're not poisoning the jury. But like, if you got something bad, you need to talk about it in jury selection and get people to open up about it. Otherwise, you're going to find out after they deliberate, right?
Right. Well, yeah, you want to have those, you want people to feel comfortable to have those uncomfortable
Yeah,
conversations with you. And that can be anywhere from, look, if your client killed somebody and this is a fatality case, maybe it's a minor who died. You have to talk to the jury and go, look, you're going to see potentially photographs. You're going to hear some heartbreaking tales about this individual. At the end of the day, if the evidence doesn't show that my client's liable, are you able to give a defense verdict? I mean, those are conversations you have to have. And it's uncomfortable because no one wants to talk about a dead minor, but you're going to have to, especially if it's that type of case. So
yeah,
again, Yeah, you got to have those conversations. You got to spend the time, and but again, a lot of it is what will the judge allow. So make sure you understand going into it, what's the judge's standard operating procedure and
Yeah,
whatnot.
yeah, not the so funny enough, I told you, talking to defense attorneys every day, um, they tell me that jury selection is one of the most uncomfortable things they gotta do. Me and my job, it's one of the most uncomfortable things I have to do. That point exactly is because, like if I'm training a witness for a deposition, well, a deposition is a deposition is a deposition.
Right.
Okay. If I'm training them for trial testimony, you got direct examination, you got cross exam. It's uniform across the right across the nation. Jury selection parameters, oh my, it's different from court to court, judge to judge, and it's like showing up for a football game and, like, you don't know which refs are gonna show up, and they could just
Yeah.
change the rules on you, right? It's like, well, pass interference is a 30-yard penalty in this particular game, it's not 15, and you have to learn that in real time.
Right.
I see that as being a big, it provokes a lot of anxiety, to have these different parameters, um, and you have to make, decisions at the line of scrimmage. I don't envy any attorney having to go through that. But yeah, I do agree with you. I think getting jurors comfortable, being yourself, and particularly in that voir dire sequence, to maybe not come out with big, heavy questions early. Gotta
Oh
get 'em warmed
God.
up, right? You gotta get them warmed up, and I've seen that happen too,
Don't
where
talk like a lawyer. Don't go in there and talk like a lawyer. Just talk like a normal person
yeah,
sitting at a bar at a coffee shop. I mean, if you're using big words, there's a chance that 25% of them don't even know what you're saying.
yeah,
Um, and
yeah,
that's not a knock on them. It's just, we're used to a certain vocab in the legal
yeah,
profession that a lot of people are not, and you can't talk over them. If you start talking over them, you're going to lose them.
yeah, and there's a rapport building, so if plaintiff counsel goes first and they've been doing it for a couple hours, well, whoever that person was has been doing their best for a couple hours to get them to open up, to earn trust, and then they sit down. Well, when you get up, that process starts all over again. You gotta develop rapport,
Right.
and then get them to trust you. And yeah, if you skip over that part, I think that would be a big, big problem going forward. So let's move into opening statement now. I'm very outspoken about opening statements. I do a lot of CLE presentations and speeches across the nation. I do a lot of consultation on opening statements because I study the art and the science,
Right.
from, neurocognitively from the juror standpoint. And again, when I give speeches about this, I tell the trial attorneys, I'm like, your brain plays tricks on you, and that's why your opening statement sucks, because what you think is good is actually the opposite. And quite frankly, most attorneys don't have any formal training in storytelling, which I think is a problem. And then the way you logically think you should tell your story is not the right way because the juror brain processes information in a very specific way. And if you don't know how the juror brain operates, what are you really doing? So I do a lot of speaking on that. And you and I exchanged some emails. I said, one of the top problems I see is these opening statements going way too long. I
Right.
mean, your attention span is atrocious. And the plaintiffs bar, again, quite wisely, and I've heard their podcast and I've read some of their papers. They figured out, hey, these jurors can't handle an hour and 15-minute opening. We need to
Right.
cut it down. And you've heard many of plaintiff attorneys saying they want that 15 to 20-minute sweet spot because they're going to maximize juror attention. I completely agree with them, but so many defense attorneys are uncomfortable with that amount of time, but they need to get through their head. That's where the sweet spot is for juror cognition. How do you approach that issue?
Well, look, I'll be upfront. I've always viewed opening statement as one of my weakest part of my game. I've always enjoyed direct and cross, but opening has always been a bit more of a struggle for me to prepare. Um, for number one, I don't personally like sitting up there for more than a half an hour. I think, if you're doing defense, the plaintiff or the jury's already lost a little bit of attention because the plaintiff's already been up there talking.
Yeah,
And so and they're going to go, hey, there's somebody new coming up. Great. Now, if you're in a multi-defendant case, that's even worse
It's
because
worse.
you may have had your friend go out, or your co-defendant go up there and
Yeah,
already do his own hour-long opening. So I always tell a judge, I need less than a half an hour.
yeah,
And the idea is hit the high points. Don't and look, I don't like using notes, so I'll try to commit what I'm going to say to the jury to memory.
yep,
And the reason I it may not be backed by science, but the reason I do it is so that I'm as comfortable as I can, that I can make eye contact with those jurors, so that I can find ways with my body language, with how my eyes are looking around them to keep their attention. Anytime I have notes, I tend to be hyper focused on those notes. I tend
yeah,
to look at them. I prefer just to have this very, nice, almost not a conversation, but just here's what we're going to be doing here. This is the theme of the case. This is what the evidence will be presented. And you go through that and you try to find ways to make sure, what does a jury remember? What comes up first and what comes up last, right? They don't remember a lot of the middle.
they
So you
don't.
want to start with your best, in my mind, start with your best fact, and you want to end with a zinger, or something, depending on your jurisdiction, maybe even anchoring with a bit of a number will show you that at the end of the day, this is what we think the value will be.
It's
And
a less
then
is more. It's a less is more process now
absolutely,
with the juror brain, and yeah, you have to be powerful. You can't waste a lot of time. You cannot get into the weeds, and I find that many of attorneys they get too deep in the weeds in opening, and and you feel great about it, right?
Mhm.
Because you're in the weeds. You're an
Oh,
attorney. You like to be in the weeds, and the juries they can't follow it and they get bored.
well, don't treat it like a summary judgment hearing where you're running through the facts
Yeah,
chronologically. I mean, a judge's mind is different than a juror's mind, definitely. And, one of the things I always do when I look at my opening is, am I making a promise that I cannot keep? And I've seen that happen several times with any attorney. They say something that the evidence is going to show this, and it turns out it was false. And to me, never say anything you can't prove to the jury. Don't overcommit. And so that's my process and how I do it. Like I said,
yeah.
I don't like any notes.
Well,
I've committed mine to memory.
yeah,
Uh,
I did rewatch for like the 700th time, My Cousin Vinny the other
Vinny.
night, and you can go with the Vincent Gambini opening. Everything that guy just said is bullshit. And then
Well,
sit down. No, so
right.
we're not talking that short, but I think you got to be under half an hour, um,
Absolutely.
and you got to hit your high points, and you got to put. I tell every because as I get sent opening statements every week, and I send them back, and we know what I do. I reorder things is what
Mhm.
I do for the attorney to say, nah, this has to go up front because you have to come out of your corner swinging, and you got to put something or someone else on trial
Right.
immediately. Because if you come out talking about you and you're defend, well, guess what? You're putting yourself on trial. I think you can be far more aggressive as a defense attorney. Put whether it be alternative causation, if it's an adverse co-defendant, empty chair, or sometimes even the plaintiff.
Right.
It's best to come out fighting. Now, after openings, then the witnesses kick in. What there's another thing I see that it's like, God, this could go so much better, and it's similar to the opening. Is I find that jurors really struggle. For example, direct examination is so important, right?
It is.
But if it's too long and it's too boring, and you start off with your witness, well, tell the jury where you're from and let's go through your CV. I mean,
Right.
the juror brain, like they want kaboom, they want
Right.
explosions, they want something sexy coming out of the gate. And if it's boring and you're kind of saving your best stuff for last, it's too late because primacy is so important. Talk to me about your approach to with your witnesses, um, the direct exam, and how you can lose the jury on the direct exam just like you can lose the jury in the opening if it's too mundane and too boring and it's too long.
Right. Well, look, you want your case in chief. The rule of thumb is I want my case in chief shorter than the plaintiff's case in chief.
Yeah.
If they do 3 days, then I want just 2 days. I want to make sure I get up there, present my facts, and get them deeded down. Start with your, sometimes the ability to start with or your scheduling of your witnesses is dictated by other things outside your control, people's availability. But I like to start with what I would view my best witness, my most charismatic witness. Sometimes that's an expert, sometimes it's not. But if you have a really good expert that is one that's more of a teacher and you need to teach them a very complex stance, and you kind of just let them, you feed them the questions and they steal the show. And then you kind of lodge your less than ideal witnesses maybe in the middle, and then you end with a couple bangers. Also, you got to kind of anticipate where the cross is coming from. You may have a great witness, but if you know the cross on it's going to be lethal, you might want to just put them in the middle or not call them at all, right? You don't want to give those sort of unforced airs to the plaintiff where the plaintiff can take someone down pretty hardcore.
Yeah, let me ask your opinion on something, because I have a very strong opinion on this. What's your opinion? And this goes for opening and for direct. It's the same issue. What's your opinion on defense counsel fronting bad issues? Meaning you bring them up on your terms with your opening and your witness, versus you don't bring them up and then it's only coming up during cross. How do you do that?
I've always felt you got to own them. You got to
Well,
own your bad
right.
facts. You got to look when you're developing your theme, you're going to have to grapple with those bad facts
Yeah.
one way or another, right? Either you do a sort of jujitsu and use that bad fact to actually support your theme, or you find a way to explain it away. If you just ignore it, I mean, it's like the plaintiff has
Yeah.
built one house, you've built another house, and you're asking the jury pick the house.
Yep.
You're running the risk that the jury themselves will come up with a different explanation for that bad fact, and it may not be to your client's benefit. So I've always felt you have to own bad facts one way or another.
I think, particularly, I do a lot of speaking. I've written 4 papers on this. You have to own bad facts during cross-examination,
Yeah.
right? If your documents or your training manual or your policy and procedure or the police report says X, the answer is yes, correct. That's what it says. You own it. You
Absolutely.
don't go into the yeah, but, yeah, but, yeah, but, yeah, but, which is called pivoting. Because
Mhm.
listen, jurors hate pivoting. Because these politicians do it. Turn on any of the major news, doesn't matter.
Right.
No one's answering a question. You see, Fannie Willis did not answer one question, not answer one question,
Yeah.
and it drives people crazy. And then a good cross examiner just reels that witness back in and
Right.
says, "Okay, well, let's get back to the question I actually asked," and
Right.
then
I'm gonna
yes,
camp
that
on this because you look so bad
kills your
trying to deny that.
credibility. And then here's what other people don't understand: when a witness pivots and starts to yeah, but, yeah, but, yeah, but, yeah, but, the cross-examiner loves that. I mean, hell, I mean, if you were if you wait, okay, so you cross-examine witnesses, Kent, right? And say the opposing expert starts with the yeah, but, yeah, but, yeah, but. I mean, you just tee off on that, right? You
Right.
love
I
you
appreciate the
kill 'em.
answer,
Yeah,
but my question was this, and you just
kill
keep
'em.
doing it until they finally acknowledge it.
It's a credibility killer, and everybody needs to listen up, because there's people out there that's like, no, the witness needs to be strong and stick it to the plaintiff attorney. I'm like, yeah, if you want to get your ass handed to you by a really
Especially
no, doesn't work.
especially with experts. If
Oh,
if the expert starts looking like an advocate,
yeah.
and they're less about the truth and more like an advocate, you're winning your war against that plaintiff expert or defense expert. I
Yep.
mean, that's part of it. Turn them into an advocate, a paid advocate, get
Yep.
out how much they've been paid. And all of a sudden, yeah, they'll say anything, ladies and gentlemen of the jury, because that's what they were paid to do. They're not here to teach you, they're here to advocate. Absolutely. I think just own it. Just say, yeah, it's in our policy. I get it's there. Safety first, whatever it
If it
is.
says that, I mean, it sucks
That's what
that
it
it says
says.
that, but there's ways around it. But yeah,
Yeah.
but shooting yourself in the foot and pivoting around things kills your credibility. I know it. Everybody knows it. The jury knows it. But still, some people have not figured this out yet, which is beyond my imagination. When is it okay? This is a really good question. When is it okay in your mind? And this is risky, but I think sometimes necessary. When is it okay for you to be aggressive, Kent, on cross-examination with a with an adverse witness that you maybe need to be more aggressive? And I know some attorneys like, I don't want to be a jerk in front of the
Right.
jury. At the same time, there may be circumstances. I'm not saying being a jerk, but I'm saying
Right.
being more aggressive with your tone
Mhm.
with a certain witness. When is it okay to do that?
Sometimes it's a bit of a sixth sense, but if you have them deviating from, say, a deposition transcript in substantial ways, you kind of lead up to the buildup of okay, and you do a big old thing, opening up the deposition transcript, and you go up there and you're just being kind. You're there, hey, I just want to refresh your recollection, kind of thing. If they keep doing it, how I've always viewed aggression is the right time to do it is when the jury will wants to see it happen,
Yeah,
right? This person is being difficult. The witness is being a jerk themselves. They're not answering the question. They're deviating from prior testimony under oath. That's when a jury almost wants you to slap
yeah,
them around a bit, right? That's when it happens. If you come out of the gate, and one of the biggest mistakes I think people make is I'm going to tear. They get over aggressive at the very beginning. I'm going to tear this witness apart because their deposition was garbage.
yeah,
How many times have you seen though when someone is a kind of gave a garbage depo, but then at trial they cleaned up and they cleaned up
yeah,
good, and you're
yeah,
sitting there being super aggressive, and the jury's going, why is Kent being such a jerk to this guy all of a
yeah,
sudden, right? And,
yeah,
so you got to it's a sense, but the sense is, and do I have an ability now? Does the jury want me to light this guy up? And when that happens,
yeah.
um, they're happy to see it happen.
It's all about timing and
Right.
opportunity, and if it's not there, don't do it, right? Because yeah,
Oh
I
no.
think what you're saying is if you come out of the gate, as Lieutenant Caffey to Colonel Jessup, go, did you order the code red? And that's like your first three questions, and you're
Right.
screaming at the witness. It's gonna be a turnoff. But if the opportunity is there, you jump on it, and it's a judgment call. I totally get that. Finally, let's talk about closing. What's your philosophy on closings? This is kind of another area where I think a lot of both plaintiff and defense counsel don't understand this. Um, the vast majority of jurors have made up their minds,
Mhm.
like we're talking like 85%
Right.
be, before your closing. Meaning, if you're going into your closing trying to persuade and convince people, you've
Right.
you've missed the boat. That's what jury selection, opening, and the
Right.
examinations were. So really, closing needs to be, ladies and gentlemen, here's all the weaponry I want you to take into the deliberation room to fight for me and in our case. And again, it's another thing I see just kind of goes way too long, and you can almost come across as desperate, right?
Right.
during your closing, and you can oversell it, and the jurors are like, seriously, and you can hurt your own credibility. What's your philosophy going into closing?
So the shorter the trial, the shorter the closing,
Mhm.
right? I mean, don't do a 2-day trial and then give a half day closing statement. It's just useless. If it's a 4-week trial, you might have to spend a little longer time just going over some of the additional evidence, especially the stuff that was at the very beginning that you want them to remember. One of the things I typically use closing for is to explain jury instructions, and I'll pick one or two jury instructions that I want them to focus on when they go back there. And there may be some complicated jury instructions that just don't, to the layperson, don't sound right. One of the ones that I did last trial did was the comparative fault instruction. And the minute I started talking about it, I noticed some of the jurors' eyes lit up like, oh, that's what I want to use because this is what this whole case has been about. It's been about plaintiff's own fault. So I'm going to focus high on that jury instruction. But again, make it short. Don't insult their
Yeah,
intelligence by going over every piece of evidence that you presented or the other side presented. Because I think they'll just get bored and turn away because they were paying attention for 2 days, we hope, or how long it is. Don't be insultive. Hit the high points,
yeah.
and I
Because you can
incorporate jury
talk your you
instruction.
can talk. I mean, and they're like, it's a whole science, which I actually study as well in like the sales industry, right? And if it's, realtors selling houses, or people selling cars, or whatever you're selling,
Mhm.
I mean, you could very easily it's called talking your way out of the sale.
Right.
'Cause you had it. You had it, and
Got
what
it.
did you do? You couldn't shut the up,
Right.
right?
Oh,
You
I
had to
agree.
keep talking, and the perception is like, "I'm desperate to sell this SUV to you, please buy it." It's a real
Yeah.
turnoff, right?
Well,
And
and I think
yeah,
a lot of attorneys write their closing at the very beginning, and I think that's a mistake. If you don't look at your closing statement as the evidence proceeds, then it may not even line up. You have to be willing to spend the
yeah,
evening before to go over what you've drafted and say, okay, I need to make some adjustments to this. Maybe take this section out because maybe it didn't sound as well, or maybe it
yeah,
was just, you don't need to highlight it as much. I mean, you got to be very fluid in how you present your case to the jury.
yeah. When people send me openings and closings, the one of the first things I do to get it to be ready is I typically am deleting one third to one half of what's on it. It's entirely too much. It's like you don't need all this. But again, your brain plays tricks on you as the attorney because your brain's like more is better. I want to be a staunch advocate for my client, and I'm gonna fight for my client.
Mhm.
And then goes like the more is better. But little do you know, more actually hurts your credibility. Come out swinging, hit your key points, focus on your confidence, your
Mhm.
power, your persuasion, use repetition to drill
Right.
some things in there, and then sit down. Just
Right.
sit
Right.
down and
Right.
show them you have confidence in them to make the right decision. All right, this is great. Like, let's finish up with a couple of different questions here. These are two very important questions, I think. Um, what advice would you give the 30 something attorney right now trying to make partner? What would you tell them? Because there's a lot of those folks that listen to this podcast, and they want to do well. A lot of these attorneys bounce around firms.
They do.
They give up too easily, and they're being ridiculed for it. They're being criticized for it. But yeah, they want to jump ahead. And what things should they be doing? And be brutally honest.
Well, so what I've seen here recently, the last couple years, is sort of the pursuit of the dollar.
Yeah,
The bigger the salary, they'll jump ship. Well, is that firm the best fit for you? Because if you're just going to get locked into an office and told to do a bunch of research memos, you'll never see it at the inside of a courthouse.
yeah,
And to some degree, you may have to sacrifice your salary, your hourly or your billable hours to go down and spend a week carrying some attorney's briefcase just to have an opportunity to sit at that table. And I did it. I didn't make as much money as maybe I could have when I first started out, but the reason why is at the end of the day, I wanted to be a trial lawyer. I did not
yeah,
want to be a research monkey, or whatever else. And if you're bouncing around again, pursuing that dollar, and you're not spending the time to find, not looking into the firm and actually saying, "Will this firm mentor me? Will they give me the opportunity to be second chair or third chair, and eventually allow me to try a case on my own?" And if you want to be a trial lawyer, and if they're not going to do that, that firm's not a good fit for you. Move on. Don't don't go there just because
yeah,
they're going to pay you a high salary. Go there because you're going to develop your skill set.
yeah,
And if you can't do that, then you need to read. You need to listen to the podcasts like this. You need to read the material that's out there. You need to focus on CLEs that are going to get you those points about trial. And you need to find a way to observe this stuff. I mean, at the end of the day, a lot of this is on paper doesn't help you unless you see it
yeah.
in action. So that's what I would recommend. Quit pursuing the dollar and pursue the experience so you can develop that, for lack of a better word, that mojo, that ability to say, I'm not afraid to go try a case because I know what's going to be there. I know
Yeah,
what to
and
expect.
if you put yourself in the right position and you accept the mentorship and you have a training and growth focus, the money's gonna come.
Absolutely.
It's gonna be there, but it doesn't need to be here today.
No.
It's gonna be there in the future, and it's gonna be better money, and you'll be a much better attorney. So I think that's really good advice. And then the final question here, because I saw something come up on LinkedIn. This does not get enough attention, and unfortunately, this is terrible. I'm gonna say it. This is terrible. But the only time this gets attention is when somebody posted on LinkedIn the other day, and it's like an attorney that everybody loved, that no one knew was having problems with stress and anxiety and depression, committed suicide. And
Right.
people were shocked. That's terrible. But listen, mental health is a big deal in the legal industry.
Hmm.
Okay. Depression, anxiety, substance abuse, it's all there. Why? Because attorneys are human beings. And I think stress management in the legal field and in other fields too, particularly in a legal field, is very, very important. What do you do personally to not let it get to you? Because I mean, really, yeah, you can overdo it. It can be very stressful. It can wear you down physically and mentally and emotionally. And before you know it, you've run yourself into the ground and you don't have any more mental or emotional resources left, and you hit the wall or burnout or whatever you want to call it. What do you do to prevent that?
Well, part of the problem is that I'll take losses or anything personally because you take on your client's problems and they become your problems. And so if you present an argument to a judge and you lose, you take that personally. It's really easy to grab a bottle and drown your sorrows out. Personally, I like to camp. I have a family. I have a
That's
newborn
awesome.
that's 4 weeks old.
Yeah,
So my family's I got a very strong family, and
awesome.
when I come home, I typically do not talk about the law or what's happened in the office. It's a time to talk about what's happening with the family.
That's excellent.
Um, Develop those hobbies, develop that sort of secondary, or I don't want to call it secondary life, but develop that life outside of work. Um, so that you at least, if you've had something that hits you hard, you can at least spend, at the after five, some time not thinking about it. But it's always going to pursue you. And if you have those demons, get the help.
Yeah,
This is not an easy job. It's adversarial. Your opponent wants to
yeah.
see you lose.
You gotta love
Right?
yeah,
Somebody on the other side wants to see you lose.
yeah.
And you have to mentally cope with it. And you got to have those issues. So I rely heavily on my family to keep me on
I
the
think that
same.
I think that's terrific. Personally, I do 3 things. Um,
You exercise a lot, don't
I
you?
go to
You
I'm in
weightlift.
the gym constantly, and
Yeah.
I lift really heavy things
Hmm.
until it hurts, and then I rest for about 2 minutes, and then I do it again and again and again. I really like that. I feel really good about that, and trust me, when you're in that much pain, you're not thinking about work. You're not thinking about your mortgage payment. You're thinking about survival, right?
Right.
So,
Right.
I love to exercise. I think that's a big thing. The other thing I do is it's gonna sound weird. I love to daydream
Yeah.
in a positive I
Yeah.
like to think about positive things and daydream about, success and, good things happening to good people. I don't yeah, I think we've lost our ability to think positively in such a negative, divisive world these days, God.
Right.
But staying positive and seeing the bright side of things is very important. And third, and I think this is the number one thing actually. Now I can only do this when I'm driving in the car or if I'm at home alone and the family's out.
Hmm.
I crank that volume and I will put on like Metallica or Foo Fighters or Collective Soul, and I will have that volume up till it just shakes the house and just
Yeah.
rock out for like an hour, right? Oh, up in your Pearl Jam, right? Maybe
Well, I'm more of a Metallica fan myself, so
okay.
that's I love listening to Metallica before trial. You get yourself in the
Oh,
right
oh,
state of
little
mind.
Enter Sandman? Oh,
Yeah,
or sad,
absolutely.
but I mean, listen, nothing will get you more pumped up, right? But I think, yeah, I think you need to, everybody needs to put,
Yeah,
you really need to put your mental health up there first. Ken, so thank you so much for being on the show. This is a really, really, really good discussion. Love to have you back on in the future. Best wishes to everything. Keep in touch because
absolutely.
always here for you guys. But thank you so much for coming on. It was great. Thank you to our audience members to participating in another edition of the Litigation Psychology Podcast. We will see you next time.